taking a break from your day and joining us for this special event. And this is not only a book talk, it's a conversation between and among colleagues in Florence, in Buenos Aires, in Madison, Wisconsin, and here in Tucson, and wherever else people are joining us online. I am Teresa Miguel Stearns. I am the Associate Dean and Director of our fabulous Daniel F. Cracchiolo Law Library. And it is my distinct pleasure to welcome you to this very special and unique faculty book talk put on in collaboration with our Latin Law Students Association. So we have three featured authors today, Sergio Puig, Alejandro Chehtman, and Alexandra Huneeus, who will join us as soon as the class she is teaching in Madison, Wisconsin is over. And they're here to discuss their new book, Latin American International Law in the 21st Century. Just last week, our distinguished authors were awarded the 2025 American branch of the International Law Association Edited Volume Book of the Year Award for the best edited volume on a book in international law. So I'll introduce our authors very briefly, and then I'll turn it over to them for a discussion of their book. There will be an opportunity to ask questions. They're going to leave 15 or 20 minutes or so for us to ask questions at the end. So Sergio Puig is the Ivo Di Concini Professor of Law, as well as Joint Chair of the Department of Law and the Robert Schuman Center for Advanced Studies at the European University Institute in Florence, Italy. Professor Puig is also Director of the International Trade and Business Law Program here at the University of Arizona, co-editor-in-chief of the Journal of International Economic Law, and director of the Max Weber Program for Postdoctoral Studies at the European Institute. Before joining the University of Arizona, Professor Puig was the teaching fellow of the Program in International Legal Studies at Stanford Law School and lecturer in law at both Duke and Stanford Law Schools. Before entering academia, he practiced law in Mexico and the US and worked at the World Bank and International Center for Settlement of Investment Disputes, ICSID. And Professor Puig is the co-founder and current vice president of TradeLab.org, an organization to facilitate assistance in international trade and investment law matters by law school clinics. In addition to this new book, he is the author of a second book, At the Margins of Globalization, Indigenous Peoples and International Economic Law, as well as many articles and book chapters. Alejandro Chehtman joins us from Buenos Aires, Argentina. He has been Dean of the Law School at Universidad de Tela in Buenos Aires since 2022. He is co-director of the Supreme Court Project at de Tela and a fellow at the Argentine National Research Council. He is also part of the research panel at Matrix Chambers, London. Dean Chehtman was previously fellow at the law department at the London School of Economics, where he obtained his PhD. He was also a member of the Faculty of Laws at the University College London, a visiting fellow at the Carr Center for Human Rights Policy at Harvard Kennedy School, and a visiting fellow at the University of Girona and Luis University in Rome. Before entering academia, he clerked at the Federal Appeals Chamber for Criminal Matters and at the Public Defense Office in the city of Buenos Aires. Dean Chehtman's main research interests are public international law, international criminal law, international humanitarian law, and constitutional law, with special interest in philosophical and empirical issues. He has published articles in leading peer-reviewed journals across the Americas and in Europe, and published a book, The Philosophical Foundations of Extraterritorial Punishment, in 2014. Alexandra Huneeus is the E.V.U. Bascom Professor of Law and Director of the Center for Law, Society, and Justice at the University of Wisconsin-Madison. She is co-chair of the University of Wisconsin Human Rights Program, which she co-founded, and director of the Global Legal Studies Program. Prior to joining the University of Wisconsin, Professor Huneeus was a postdoc at Stanford University's Center on Development, Democracy, and the Rule of Law. Professor Huneeus is a member of the American Society of International Law and the Law and Society Association. She has served on the board of editors of the American Journal of International Law and of Law and Social Inquiry. Previously, she served on the board of trustees of the Law and Society Association and the American Society of Comparative Law. In 2017, Professor Huneeus was named to serve a 10-year term as foreign expert jurist in the Colombian Tribunal for Peace, a court created as part of the Colombian peace process. And in 2014, she was awarded an NSF grant to explore the impact of the Inter-American Court of Human Rights on domestic prosecutions of state atrocity. Professor Huneeus' prize-winning scholarship focuses on international law and human rights, with an emphasis on Latin America. Her work has appeared in top law journals across the United States and Europe, and before becoming a scholar, she worked as a journalist. So the authors will now present their book, and they plan to leave, as I said, 15 or 20 minutes for us for questions and answers, both online and here in the room. I'll help with monitoring the queue. So please join me in welcoming Professors Puig, Chehtman, and Huneeus today, and congratulating them on the publication of an award for their new book. Welcome.
Well, thank you so much, Teresa. Thank you so much for that generous introduction and for organizing this event, and also to Nikki Carpentier for her time and also devotion to keep doing these beautiful events with the library. I also want to extend my thanks to not only to my co-authors or co-editors in this project. It's a wonderful project to work with them, and all the credit goes to them. But I want to also express my gratitude to Mark Miller, who was very supportive of this project while he was dean of the law school, and he was very generous not only by supporting trips to Argentina and other places, but also making sure that Alejandro spent some time with us as well during one semester. So thank you, Mark, as well. And the others thanks go to Negar Katiray, who cannot be here with us today because she had to take care of the kids, but she actually was in the background of all the conversations that we had, because this book started as well, mostly or being developed during the pandemic. So a lot of the conversations happened throughout the pandemic. And that really, it was a wonderful way to really get to know the field of Latin American studies and another field, because we started with several conversations of how to frame the book, how to think about the book in many ways. So the pandemic proved to be very good in that sense, although it delayed our finishing the book for several months. But it was very fruitful to open our exploration to different areas of international law and Latin American studies. So I'm going to just share a quick PowerPoint where I summarize the main argument that we're making in the book. And then I will let Alejandro Chehtman to present his chapter, which is not only because I think it's one of the most interesting chapters of the book, but I felt like that could give us a bit of a sense of the type of the content of the book. So what are we attempting with the goal with the book? Well, the book was basically a way of moving a bit away from this North American or North Atlantic centrism in international law studies, right? We tend to see that there's a lot of conversations around European law or European international law, or the way in which the US has influenced international law, or how international law gets absorbed by the US. But not really, there was no single book that could actually discuss the way in which Latin America has contributed to the practice, the doctrines, the institutions, and the scholarship of international law. Maybe with the exception of one seminal paper that really appeared in the American Journal in 1907, in the American Journal of International Law, which we all have studied, or every international lawyer has studied. It's a really wonderful paper by a Chilean, now deceased author, who basically framed Latin America as a as a Pan-American project, right? The Latin American International Law was a Pan-American project where the US will be at the helm of the development of law in a way to move away from European empires and the time of empires. And this is 1907, the US is gaining force. But the field today looks much different, right? Europe doesn't exercise the power in the world or in Latin America that it used to, and in the US as well, right? So one of the main aspects of the book is trying to document that change, right? That radical change in the last 100 years. But in any event, despite this radical change, I think there has been a continuous on the use of Latin America, of international law in the region. And it has to be a little bit as a resistance to the expansionism, the way in which different empires or different more aggressive actors in the world or nuclear powers have behaved towards the region. So it has helped in that way by absorbing international law and recasting international law in a way that's very unique. And here I wanna emphasize, maybe make the point with a little bit of a song, and I hope you can spend like a little time listening to it, because it's something that it's a song that I really enjoy, and it's a composition by an Argentine musician, Osvaldo Gollejov, who basically takes one of the biblical stories as if it was told by a Latin American composer. So I'm going to play it, and then I will delve a little bit into it. In this song forever, really, because it's a magnificent composition that really shows a little bit of the dynamic way in which music plays such an important part of the region, but also the way in which I think I perceive part of the use of international law by the region, right? So in this song, that I don't know if anybody was able to understand, right? But this is the San Matthew's Passion, right? Reinterpreted, right? And so it's talking about Judas, el Iscariote, fue quien lo traicionó, right? Like Judas who betrayed Jesus, right? And sold it to the bosses, right? And it's a wonderful way in which this classical story of the Bible or classical music can be used in different ways, or classical stories can be retold in different ways. So we wanted to do also to bring that type of flavor into international law, right? So I think it captures the flavor that we wanted to bring, and that is often not captured by North American books of international law, and also those who are more focused on North Atlantic perspectives. We also wanted to give a voice to leading and emerging scholars, including indigenous peoples, rights scholars in Latin America, and many young scholars who often don't have the possibility to contribute for these wonderful type of volumes, right? The Oxford Handbook or the Oxford edited collection sometimes tend to be close to a group of people, right? That these networks tend to be very small and not very open, and we wanted to also give voice. And so that was very, very nice and refreshing, because not only we have very senior and consolidated scholars participating in the book, but also young and diverse members of the continent. And the other one, I think, finally, is advance the scholarship on Latin American law on the region, right? So that's obvious, and I think like at least this is something that we're contributing a little bit. So what are the elements of the book? So it's a long book, big book, someone was remarking that, so there's 30 chapters, plus an introduction and an epilogue that the three of us co-authored. We each have a chapter there, and mine is more about the growth of interdisciplinary studies in the region and how that has been used to imagine different forms of social and economic organization in the region. And truly, the chapters of, if you had to read 2 chapters, don't read mine, read Alejandro's and Alexandra's. They are the best. And read the epilogue and the introduction. I think those are also very good. It's divided in 5 different parts, and maybe, you know, in the Q&A we can go more into why we chose this. One is the history of the international in the region. The other one is the theory and methods, and explains a little bit that move away from positivism and how even that positivism serve a purpose at a time. The institutional practice, right, that basically focuses a lot on the developments at the Inter-American Court of Human Rights and the Inter-American system. The more technical part is the new doctrines, right, that have been developed, and the contemporary challenges. And as I was saying, authors from the region in different ways. And I think we acknowledge that perhaps we are not making a complete, we're not giving complete justice to the region, because we couldn't really find authors from all the places that we wanted, or we couldn't, at the end, secure contributions for some people from certain parts of the Caribbean, and I think like other parts are a little bit underrepresented. But in general, I think we wanted to do to give some representation to different parts of the continent. What are the conclusions in general, right? So this is the big thing. So what we came after 5 years and many conversations and 30 chapters, and an amazing amount of talent contributing to this. Well, I think one is what I was saying. I think international law in the region continues to revisit doctrines and arguments of the past, and that's in part because it continues to be used as a way to deflect, different aggressive tactics against the continent, or extractivist practices, or the dispossession by different corporate actors of property of people in the region for different reasons. If you think that's not true, just think about what just happened last week. A naval, a small boat was carrying perhaps some drugs from Venezuela, was drowned and killing 11 people. And now in the New York Times, if you read, you will find out that these people were not actually on their way to the US, they were on way back. And the US is claiming that this is legal under international law. And actually, Alejandro can tell us a little bit more, because this is his area of expertise. But if you think about that, you can see why international law has to be revisited and reframed in ways that can serve the continent. Otherwise, we will be in deep peril. And it's interesting, right? Because like now, as I was working on the book, really there was a turn in the U.S. Engagement with international law, right? So I think the U.S. has for many years. Maybe during the 90s, right, engaged in much more good faith in international law. But I think like since the Trump administration, or a little bit before, depending on how you think of this, you can see a much more aggressive tone and the deployment of international law in ways that basically advance the interest of the US without really concerns to any of its normative and ethical dimensions. So I think it was really interesting to see, and also made me reflect on the past 100 years, right? When my great grandfather, who was a diplomat, who was very skeptical on engaging with the US as a diplomat, always felt that this was the way in which the US used international law, and it kind of like circled back to that use of international law. So I'm not surprised that we came with this conclusion, also given the times. I think one other part that it was really interesting to see is how it has changed, right? I mean, one thing is the dimension that remains, but then the dimension that changes. We have changed from an international law that basically was very much constructed by the elites in Latin America to one that is now part of a broader part of the society, including domestic judges, civil society, indigenous peoples, and other processes. The human rights law, it's one that has actually the highest level of coordination and cohesion, and perhaps originality because the doctrines that it employs, and it's always framed around the Inter-American system. And I'm running a little bit because I think it's more interesting that you hear from Alejandro, but I want to hear with this. I want to live with this. I think another part, and I think you will find this interesting, is how the US that has been mentioned different geopolitical issues and problems and has given really very little options to the region, right? It's by talking only about immigration and drug policy has actually give away its influence in the region, which is now taken by China. And I want to also finish with a different song. I think that also brings back a little bit.
Okay, before you do that, we couldn't hear the first one, yeah? So I think
you couldn't hear the.
No, that's.
Okay. Sorry about that. So, well, maybe I played the two of them at the end, right? So basically, for those who want, because they know otherwise, and so we can go back. So excuse me, I didn't know that it wasn't played, but I will go back to this. And with that, I see the floor to Alejandro, who will be presenting his contribution to the book and also talking about the book. Thank you so much.
Thank you very much, Sergio. Thank you, Teresa, for organizing this book launch, this event, and to Nikki for the work you put into it, and also to Dean Miller and to the whole faculty of law at the University of Arizona. I spent a couple of great months there a few years back, and thanks to Sergio for proposing and organizing every detail of it. So I'm very happy to be talking about this book, which at the time was still we were struggling with getting the chapters, commenting on them, and so on and so forth, as you know. I'll start. So my chapter, as Sergio was mentioning, is about how Latin America became a laboratory of transitional justice, and it. One way to start speaking about the role of Latin America is perhaps with the contrast Sergio drew with sort of a scholarship and dynamics and synergies coming from the North Atlantic into the region and into the world in many instances. So there's a recent chapter by two great scholars, Sarah Owen and Neha Jain, who argued that in the 2000s, transitional justice became a kind of a toolkit, sort of a recipe that was developed in the global north and imposed from the global north on many countries in the global south. And I think that captures an important part of some of the more recent history of transitional justice. But what it obscures is how the field of transitional justice, and I would go further, some of the relevant aspects of the field we standardly call international criminal law, were developed in Latin America. So the chapter essentially advocates four main claims. One, it looks to the number and quite remarkable instances of legal innovation. Now I'm writing another paper with two colleagues from Colombia. We distinguish between innovation, hybridization, and adaptation. But the notion is very clear that there was a lot that was genuinely new, and secondly, that there was a big or an important process of cross-fertilization among countries in the region, with ideas that were developed in one country and then applied to a different country. So the second point is how ideas moved from country to country by tracing the specific agents that carried those ideas from one place to the other. The third claim is that this field we now call transitional justice was developed in Latin America as kind of a regional project. It was not the project of one or two countries, but rather a bunch of ideas that were widely spread and widely debated and innovated upon. And the final, the fourth claim is that we have to look into the role of victims in much more detail. So there are a number of milestones in Latin American transitional justice that I think are worth pointing out from the outset. It was the first operative truth commission in the world, and many of the subsequent models were developed in Latin America. It was the first time a local court tried the former heads of a military junta, the former heads of state for human rights violations and international crimes, what we now call international crimes. Argentina and Latin America more broadly was the context in which the whole practice of forensic anthropology to investigate massive human rights violations was developed and then exported to Africa, Asia, and other parts of the world. People there came up with the idea of the right to truth and to identity that were then incorporated in international treaties, the right to identity, or in the case law of international tribunals, including the Inter-American Court of Human Rights, of course, but also the European Court of Human Rights, and now the African Court of Human and People's Rights. Conditioning penal benefits for truth, international crime of enforced disappearance, and I could continue for a few more minutes. And one of the things I found great about this particular project is that when I started, I mean, when we discussed, of course, the book, we discussed what each one of us was going to talk about. And I said, oh, I'm going to talk about international criminal law, and I've done quite detailed work on Colombia, and I had already done detailed work on Argentina and on the Inter-American Court of Human Rights. And I had quite good understanding of the dynamics in Uruguay and Chile and Peru. But then when I started the research, a whole new research agenda opened to me, which showed that even myself, which I have been trained and largely embedded in this practice, I felt I had so much to learn. And what started as a, I don't know, 6 months, 8 months project, as, oh, I'm going to get it. And I thought, initially I thought it was going to be shorter, but eventually I thought, well, 6 months, 8 months, it ended up being a 2-year project. I'm still working on it and has become a large part of my scholarship because of the number of and the richness of the stories I found. So the paper or the chapter has 4 sections. One is the foundation, so how it all started. This wave of transitional justice started in the 1980s, where in Latin America we were having transitions to democracy as they were going on in Eastern Europe. But those transitions were essentially about impunity and no revision of the violent criminal past by past regimes. So it was moving on. Spain is a good example of that in Europe, but also in Chile, in Uruguay. And so the 1984-85 events in Argentina, some of them were captured by a recent movie, Argentina 1985, which tells the story of the trial of the juntas. But before the trial of the juntas, which was a remarkable path-breaking event because how successful it was in bringing those at the top of the responsibility ladder to trial, and some of them being convicted in a trial that has been almost unanimously considered a model of justice and of due process and safeguard of basic guarantees and of robust evidence. It was preceded by a notion or the creation of this truth commission called CONADEP, which was essentially pushed by members and carried out by members of victims organizations. So it was the members of victims organizations which gathered all the evidence. Part of that was during the 1970s when they were trying to find their relatives who had been disappeared. They moved all this evidence and systematized it in the Truth Commission, and that was the evidence that was used in the Junta's trial, which I'm teaching now a course at the Tela on the Junta's trial with the deputy prosecutor of the trial, Luis Mario Campo, who then became the prosecutor of the International Criminal Court. And we were discussing last Thursday, they had essentially less than a month to present all the evidence, and they were able to do that. They were able to do that because they realized that all the evidence had already been collected by the Truth Commission, and the Truth Commission had been the work of the Truth Commission had been carried out by all the members of these victims' organizations seeking. So the push for justice and the push for accountability and the push for truth can be directly linked to victims. Now, that process, as some of you may know, did not end up well in the short term because there was a military, not a coup, but military demonstrations that the military were not prepared to accept the expansion of the accountability model into the lower ranks. And so Argentina passed two amnesty laws and then issued certain pardons. But this gave way to a push for truth in the region. So the CONADEP was the model, and it influenced a parliamentary commission in Uruguay, the Chile Ethics Commission, which was the first one that was called the Truth Commission, the 1992 Commission in El Salvador, which was pushed by the UN, so it was a global north influence, but the Secretary General of the UN was, of course, the Peruvian Pérez de Cuellar, who believed that the model of Argentina had to be exported and convinced El Salvadorian authorities and non-state military groups to accept this kind of arrangement. And they were the first one who created the idea that people could exchange, let's put it this way, truth for justice. So if they were truthful in their confession of all the crimes, they would not be prosecuted, an idea that then became very popular in the South African Truth Commission, which is perhaps the most famous Truth Commission, but the core of the ideas were already developed in Latin America. In fact, the people in South Africa came, so the people in El Salvador hired an Argentinian on the grounds that she must, of course, know everything about the CONADEP. And so they sought to bring the Argentine experience into El Salvador, and the people from South Africa interviewed her and interviewed the people at CONADEP to exactly find out how they performed this. So the experiments with truth commissions were significantly influential both in Argentina and elsewhere, and now there are tens of truth commissions that have been created around the world. The second, so that was the 1990s. The late 1990s and the early 2000s began with the problem of justice, and the idea was, well, we want to prosecute those responsible for that. Initially, there were amnesty laws, and of course, there's the further problems of statutory limitations, now that 20 years or more had passed, and of course, of investigations. How do we gather evidence? And it's interesting that Latin Americans developed the legal and technical knowledge to overcome this limitation. So in 1988, an Argentine judge solving a case of a Nazi official whose extradition was being requested by Germany came up with the idea that certain criminal prohibitions, such as crimes against humanity, should be considered jus cogens norms, and as a result, they defeated Argentine domestic laws on statutory limitations. So again, they found a legal reasoning, a legal argument to overcome statutory limitations that, of course, then was applied to more broadly to other crimes by other courts in the region, and even ultimately adopted by the Inter-American Court of Human Rights. And similarly, this idea of jus cogens norms was used
think we lost Alejandro.
Sorry, I guess I'm going over time. So let me be very brief. So the justice aspect of the accountability process was largely developed in the late 1990s, early 2000s by different courts talking and developing ideas, and of course by the whole Argentine team of forensic anthropology that was able to conduct investigations in Colombia, in Mexico, in Peru, in Chile, in Argentina, and in Uruguay, and of course in Vietnam and other places around the world. So the techniques of investigating these crimes was also developed here and then exported. So that created a big push for accountability, and you have prosecutions going on still today in Argentina, Chile, Uruguay, Peru, in Colombia, and I'm going to talk about the last bit with peace. And there's push for prosecutions in Mexico and other places. So the last bit of development is the idea of peace and how we can secure peace through transitional justice. And then the Colombians wrote quite a bit about it. In fact, there's a great piece in our book, which, as Sergio was saying, if you have to read one, you might read Elena Alvear and Laura Betancourt's piece on the Colombian peace process, or Sergio's or Alex. I think that the book is genuinely quite interesting because we are all talking about things which are really distinct and unique. So Elena Alvear and Laura Betancourt talk about how Colombia had to create a new type of legal arrangement to, on the one hand, secure peace with the FARC, on the other hand, make that peace resistant to the push for greater accountability and harsher accountability that was very prominent in the region, and that model that has now been articulated in the I see Alex is now with us, which is great. That model, which has now been articulated in the Special Jurisdiction for Peace in Colombia, I think is genuinely innovative, and it seeks to bring together several of the ideas that were developed in Argentina, in Chile, in South Africa, in Peru, and elsewhere. So I'll leave it at that. I hope it wasn't too messy. Thank you so much.
Thank you, Alejandro. And maybe I let Alex, you want to say something before we open this for questions?
Can you hear me now?
Yes.
Good. Okay, I had to change computers. So first of all, thank you so much for inviting us to do this book panel. I unfortunately I had class until 2:30 and then had to get over here and get on Zoom, but I'm very happy to be here. Incredibly happy that our book is out, and I hope that you find it of interest. I think since I don't know exactly what Sergio said at the beginning, that I should probably just bow out now. And if there's
Can I make a small suggestion, because I think this is interesting? This is one of the many, the very, very long list of Alex's contributions to the volume, but she came up with the notion there's a new canon in Latin American scholarship. Perhaps you can say a few words, because I think that's relevant about why the book has the title it ultimately has, and yeah, I'll leave it to you.
Sure. We started with this concept, right? Latin American international law, as something that had been created in the early, in the early 20th century, really, and advanced. And we looked at it, as something in the past, and this notion that we wanted to explore, but without taking a normative stance on whether Latin American international law existed, or to advance the argument that it existed. Really, that to us was just something from the past that we are using to organize our book, but not something that we were proposing. But through the more, as each chapter came in, and then towards the end, we had to read them all together, it really stuck out to us, I think, that there were some themes that ran through the chapters that spoke to a sense of there is, we don't want to call it Latin American international law. We said a new canon of international law. There's certain themes that seem to run through all these chapters that point to the idea that there is a practice of Latin American international law that characterizes that practice today that is different from what it was in the past, and that is different from the practice of countries not in Latin America and from other regions. And some of the features that demarcate and distinguish it from the past are, for example, in the past, the whole claims of Latin America to have a Latin American international law was really a way of inserting itself into and getting Europe and the United States to take it seriously as a member of international law, right? So Latin America has independence in 1820, so it wasn't like the decolonial movement of the 60s. They were there, you know, from the early 1900s, but they didn't really have an equal place at the table. So this idea of Latin American international law was a way to fight their way in and create and forge a special relationship with the United States. That's not what we see today. Today we see that the United States, and mind you, we wrote this book and finished it before the current Trump administration, where policies to Latin America really might convince us to do yet another volume. But even at that time, we could see, you know, the influence of the United States over the past decades has just dwindled in a very dramatic way, while at the same time, the influence and impact of China, and then also Europe and Russia as trading partners, for example, has really become important. And that really distinguishes the current day practice of international law from what it was in the early 20th century. And then one of the other features that really stood out to us, and there are more, but I'll just highlight this one, is that the human rights law practice, both constitutional and inter-American in Latin America, has become something that shapes not only international human rights litigation, but domestic constitutional law and other areas of domestic law. So many of the chapters that we commissioned that didn't have to do with human rights prima facie on its face ends up citing to the inter-American system as a source of norms and standards. And so another feature of this international law is not only that it's not just outward looking, not US focused, but also regionally focused and very much centered and shaped by the inter-American human rights system and the treaties that have been made through the OAS regarding human rights. So those are two features that we think are really interesting and stand out in the contemporary practice of international law in the region and are part of what we call the canon of international law. I'll leave it there because I don't want to take up more time. We only have a few minutes left for Q&A.
There is a question in the chat for you. How might Mexico's recent reform of the judiciary shape its understanding of and approach to international law?
Well, maybe that's more for me. I don't know, but I don't know. You are also very plugged with the conversation. But let me just start by saying, and the law school in general is very close to the the University of Arizona's law school is rather close with the new president of the Supreme Court, because it's someone that both James Hopkins and I have worked directly with, and someone that we think is very talented, I think. I don't know if James is there or online, but
Yes.
Yeah.
oh yeah, yeah. So, hi James, it's good to see you.
Yeah.
And talking about Hugo, you probably can say a lot of very good things, and I think it's someone who I think does believe in international law because as a human rights activist and lawyer, they have deployed international law in a way that advances the progressive views of international law, and then also as a resource to harmonize the Mexican legal system much more with the normative values of human rights. So I think that has a potential good effect. And I do, but I do think, and this is interesting, right? Because I have been invited by him, and my co-author in another project, Jim and I was actually in the ceremony, on the swearing ceremony. But it's delicate because the reform is a reform that has problems, right? It's a very delicate way in which they change the entire judiciary, and then the elected judges is like actually quite controversial. So it remains to be seen. But I do think that at least at the level of the Supreme Court, I have a hope that maybe the president will help in that regard. The president of the Supreme Court. Yes.
I'll add something. I think it also, this is a problem that the Inter-American system has to decide. The Inter-American Commission has to now decide whether it's going to take on the judicial reform, because the complaints are coming to the commission that this is a violation of the American Convention, and some of the the court and the commission have elaborated standards about judicial independence that are increasingly sort of specific, and there's ways in which the Mexican reform is thought to be in violation of those standards. And so the Inter-American system might weigh in a way that the Mexican government doesn't like, and and finds that the way the reform was done was a violation. And so I think there's an interesting political question there that will, I think, also define how what the relationship between the commission and the Mexican government are moving forward on the question of the judicial reform.
Are there any questions in the room? If not, I'll go back to the chat for a couple of questions. Okay. All right. We have two questions in the chat for our guests. They're related, so I'd like to read them both, and then have you all answer them. How might the U.S. administration further distinguish or highlight Latin American international law sketched in the new volume? And then secondly, related, Alex, you mentioned writing another volume in light of recent developments in U.S. policy toward Latin America. How would you write the book differently if you were writing it today?
Maybe Alex.
I mean, the second one was, so much has happened, right? The Trump administration's announces during the first week that this total violation of Panamanian sovereignty, and then just last week struck a civilian ship on the Caribbean Sea claiming that they were Venezuelan, but at least the last I looked, we don't know what nationality they bore. But there has been such fundamental changes in the approach to international law and to the region in particular, that I think if we were writing it today, we would have to at least have a chapter, if not rejig the whole thing, but I think at least have a chapter looking at some of these approaches have deep roots actually in the history of the United States and Latin America, and it's nothing new under the sun. It's new in the contemporary era, I would say, in this millennium, in this century, but really nothing new under the sun. So I think it would be interesting to put some of those actions that the administration has done under a historical lens and see and perhaps analyze it from that perspective. But at the same time, this is still this new era where China plays such a big role in the region, that I think these actions by the US will have different repercussions than they might have in the past. But so yes, definitely one thing I would do if we were still, be about to publish is we'd have to talk about the emerging relationship between the United States and Latin America.
And if I may add one point to that, because I would have, I echo exactly what you said. And I do think that sadly it's not just the Trump administration, right? I think this is a phenomenon that maybe will go and will not die with Trump, And I think like the people, I was just in Mexico, and I think people are preparing for other things, right? I think the the declaration, for instance, of the cartels as terrorists, that enables the entire apparatus of drone attacks and what have you, right, to be deployed. Even the taking of territory in Mexico. There's also talks that the U.S. will eventually not only take Greenland, that's for sure, but in Mexico, given the history that the Baja Peninsula that is across the coast of Sinaloa, right, can be used as Sinaloa, that can be used as an excuse to exercise jurisdiction and control over parts of Mexico, which I think it's very, very dangerous what it's happening right now, and I think you can see in Mexico exactly what Alex was saying, right? That this revival, oh yeah, this is the devil that we know, and it's just creating also this nationalistic fervor is deployed to organize people in different ways and to create more distrust. And maybe you're right that the questions of the influence of China will make this relevant in other parts of Latin America. But I think if we see a part where China is still not very influential, is Mexico. So I do caveat that as well.
Can I add two minutes on this question, which I think is relevant? So on the one hand, I think a large chunk of the book stands because it kind of captures a sensibility, ideas, developments that I think are useful, particularly for countries that had to come out of a very, very criminal, harsh regimes, and they went through a lot of. So there's a story there that I think is relevant for the world as it becomes increasingly violent and we see increasingly more or different types of human rights violations. So that's one thing. A second thing which I think is important is that it reinforces our idea that the key political project is about Latin American international law, because in parallel to this project, there are other projects. Some of them take the notion of Pan-American law, and it involves the idea that there's one regional hemispheric legal project that goes from Canada to Tierra del Fuego, and we think that there's something specific and relevant, and that it's important to capture about the Latin American region as a source of legal development, legal dialogue, legal doctrine, and so I think these developments reinforce that idea and that sensibility. And the third is, as Sergio and Alex were saying, we are increasingly in entering a world of a clash of two superpowers or two big blocs. And Latin America, which was completely under the radar and left largely alone by the US for a number of years, now has become part of its concern, and that's not necessarily a good thing. But Latin America has to think very carefully about how to navigate these greater tensions that will face upon the harsher conflict between the two blocs, and its role is going to be very, very difficult to navigate properly. So I think that there are strategic questions, and that as Alex and Sergio were suggesting, I think it's urgent that we think about. And we have the further problem that of course some of the challenges come from outside of Latin America, but many come also from inside, from regimes like Mexico and its judicial reform and other policies, Argentina and some of its policies, some of the Colombian policies, Venezuela, Cuba. So indeed, the general structural context of conflict between two superpowers or two blocs and the tensions inside the continent make us have to think very carefully and very deeply about the challenges ahead. I do think that, going back to Alex, so we have some language that can help navigate some of these issues. We see how hard we can hold to that language and to those institutions. That remains to be seen, I think.
I
know
don't see other questions in the chat. Are there any questions in the room? No? Okay. I think we're about to run out of time. We have just a couple of minutes left. Would you all like to say any closing remarks, Professor Puig, Chehtman, or Huneeus?
Well,
I would love to thank you, Teresa, for organizing this. I really appreciate it, and it's wonderful to be able to reflect on the book with an audience in University of Arizona. So thank you very much.
thank you, and I'm sorry for jumping in. I was just saying that I would like to play the song because I talk and no one listened to it. So if possible,
Go for it.
yeah. And you tell me if it
Sure.
doesn't. Okay.
I'll let you know.
Are you listening? Did you hear it?
Not really. It's quite broken up.
Oh, quite broken up. Okay. Well, then, well, I will
But
say.
we can try and splice it into the YouTube video that we'll create from this event.
Perfect.
Okay.
And for the line, I will just share with the link to listen because it's really in the chat. It's really a fantastic.
I'd love to hear it. So please send it along to me.
Perfect.
All right. Well, thank you, Professors Huneeus, Chehtman, and Puig. Thank you for joining us today. And thank the Latine Law Students Association for co-sponsoring this event and being here today. And thanks to all of our colleagues from across campus as well for joining us for this fabulous book. And congratulations once again. Thank you.
Thank you so much. It's been great.
Thank you.
Bye.